So to give you an example of a legal action, Werner versus Autodesk is one of the famous ones. And what happened is Autodesk issued a DMCA takedown notice to Timothy Werner. Timothy Werner was selling their software. This is back in the days when you got it on disk or whatever. And he was selling it on eBay. And they said, no, you can't do that. And Werner sued Autodesk right back, saying, yes, I do have the right to it. And his reasoning was there was something called the first sales doctrine. And that means if you own a DVD or a digital recording of something, you were allowed to sell it to one person. And the same went for movies and things like that. And that's why you could sell those things used. Now, where you got in trouble is with Napster, where you're trying to, give it to 1 million people. No, you're not allowed to do that. But this is why people can make mixtapes and things like that back in those days. And what happened is Autodesk appealed, and they won. And the reason why they won is if you look at all that fine print on software, it tells you that you are a licensee. You do not own the copyright to the material. You are just owning the right to use it, but you do not have the right to go ahead and sell it. And so you have to read that fine print carefully. Now, in terms of a software copyright, the progression it's undergone is in 1974, they recognized that it is software. In 1980, they recognized that you can make a copy for your computer. And then 1998, DMCA addressed the digital economy. And one thing they talked about was safe harbors. And the idea behind it is that for the ISP providers, they're again renting space out on their website. They're not necessarily giving away ownership of their area. And so it's the same thing as like I own a building and I rent it out. Well, when I rent it out, I am basically licensing the ownership of that particular apartment to you. So if you break the law, I'm not, as long as I don't know that you're breaking the law and I'm not complicit of having to have done anything with that, then you can't, I can't go to jail for it. I'm tongue-tied today. Anyway, some of the copyright concepts are fair use, and that's what they consider to be fair use, fair implementation of it. Copyleft means that the copyright has, you can license it and redistribute it. And also a copyright is about look and feel. So, for example, the typefaces of software is actually a copyright. It's considered to be art, as well as your menus, buttons, and boxes. To me, one of the big abuses of this is Apple Computer. Apple argued that its icons and everything were unique when they made the iPhone. The thing about that whole Apple lawsuit is Apple had to file that 4 times before it got approved, which a regular company can't do. One of the biggest lawsuits was Viacom versus YouTube. Back then they weren't Google, today they are. So Viacom sued YouTube because they saw a bunch of their movies and stuff on YouTube, and they were angry, you have to stop this. And YouTube, though, claimed safe harbor, that they can't be held responsible. They got billions of users. How can they track everything? And so what ended up happening is a U.S. District Court ruled that safe harbor applied and there wasn't going to be a trial. So YouTube won. In the U.S. Second Court of Appeal, though, Viacom files an appeal and they won. So it went back to court. YouTube ended up winning the trial. And the moral of the story is lawyers made a lot of money. But anyway, so eBay and companies like this pretty much can't get sued as long as they know you're not doing something wrong. What about international law? Well, the thing about international law is that they all kind of have different rules, and they differ on penalties and the length of your patents or copyrights and things like that. And so The thing you see, though, is that the U.S. legal system does look at the evolution of this technology and see how does this compare to the spirit of the original laws, or do they need to pass new ones. And so these are the types of things that copyright can cover, whether it's drawings, paintings, presentations, all of these types of things. And so that brings us to patents. And what a patent is a patent is a right to exclude. You exclude others from doing what you do, so they can't make it, use it, or sell it. In exchange for this protection, you have to publicly disclose your invention. I love patents. You could go to uspto.gov, pay $3 and see what somebody's doing. But the patent rules also protect against innocent copying, like you may have copied it and not known it. And also, you are allowed to reverse engineer things. You are allowed to take things apart. The big thing, though, is you can't go ahead and start making money off of it. What is considered to be an invention? An invention is defined as new, useful, and non-obvious, which means the useful arts. And so your invention serves a purpose. It's not within the prior art, meaning nobody's ever done it before. It's got to be a patentable subject matter. And it also has to be non-obvious. And this is one of the big controversial clauses in patent work. And that's that they say it's not obvious to a person of ordinary skill in the art. The problem is who is that person and what is that standard? And it could be arbitrary. And that's what drives me nuts so about the patent office. Now, purpose and utility are two totally different things, or can be two totally different things. For example, a hi-fi machine. It serves a purpose, but how useful is it really actually? And the granddaddy of them all, bird diapers. Yes, somebody got tired of birds dumping on their cars, so they actually got a patent for diapers. And the thing that's scary is it's 1999. This thing is still under patent. So yes, don't infringe those patents. The thing is, you're recognized for inventorship, but it doesn't protect the right to practice an invention. For example, you could patent the rowboat, but you can't patent rowing. Typically, a patent term lasts about 20 years. You have to pay maintenance fees over that lifetime, and we're talking potentially like $100,000 or more. If you stop paying the maintenance fees, then your patent becomes void. The America Invents Acts. Ugh, drives me nuts. Okay, first of all, the patent law used to be first to invent. If you had the idea first, you can invent it. Then it became first to file, and that was the AIA. And what that meant is that whoever filed the patent first, those are the ones who own the right to it. And this is bad for the entrepreneurs, because before, the entrepreneurs could wait as long as they wanted to file because they had notebooks and other documentation that showed they thought of it first. Well, now whoever files first. And the thing is, this really speeds up the entrepreneurial process, because you have to hurry up and get the cash or raise money to pay for these sort of things. And not only that, but the other thing you worry about is a lot of people are filing provisional patents because they're cheaper, and we'll talk about that in the next lecture. But it's just not good for the entrepreneurs. And the way this whole thing got started is because they said, oh, there are a bunch of unscrupulous people out there who just file patents. And if they file patents, then they come back and sue the larger company just to get money out of us. Well, first of all, the big companies don't really have an issue with that. This thing doesn't happen too often. And it's just quite simply, the little guy just doesn't have enough money to file lawsuits. It's the big guys who have all the advantage. And so, to me, they created a solution to a problem that wasn't really a problem, but that's just my personal opinion. Okay, what a provisional patent is a placeholder. It's only a couple of $100. I file provisional patents before. And you have a year before you have to file the real patent, the real full disclosure. The problem is, if your full patent is significantly different than your provisional patent, then you think, okay, I have the rights of coverage from the day I filed it. No, that gets voided. It's the date where you filed your full patent. So someone else filed another one on top of you, thinking that you were going to blow it. Well, they won. Full patents are pretty expensive. It's anywhere from $5,000 to $10,000. It takes a year or two before you're granted, and typically you need multiple patents for a product. Some of the concept and patents are prior art, meaning how did it exist before? That it's novel. There is no prior art to it. Talked about posita, and also obviousness. How do you define obvious to those skilled in the art? The types of patents you can file are utility patents, which cover things like processes and machines. Design patents, which means you have an ornamental design. Those last much less than utility patents. Those are your patents of fashion. And plant patents. And it's because what was this country founded on? Agriculture. So they're still byproducts of a bygone age. Some other kinds of patents is you can get a re-examination patent, meaning I want another opinion. That's what Apple did. Reissue a patent, meaning you found an error in it and you want to change it. Or if you want to make additional improvements, you can refile. What is patentable? Here's a list of things. It's pretty straightforward what they are, whether it's methods or compositions of matter. What is the value of a patent? The thing is, a patent is only worth something if you're willing to defend it. That's the big thing. It could be long and expensive. For startups, patents tend to be good for property, but they're weak on protection. It doesn't scare a big company off. One very, very sad story is a friend of mine in Silicon Valley. He left Intel, and Intel built big honking processors, and he had an idea for a mobile low power processor. Because he was so high profile, the first thing that happened to him is when he left Intel is they sued him. And they sued him, and they sued him, and they sued him. And he had actually raised like $10 million. And then he finally threw in the towel because Intel just bombed him into the Stone Age. And Applied Materials does the same thing. That's why in Silicon Valley their nickname is the Evil Empire. A lot of companies do it. And it's the advantage that big corporations have. The thing is, what big corporations do, and this is why guys from big corporations who have a boatload of patents, I just kind of sneer at it. Look at their patents sometime. They've got like 10 authors to it. Are you telling me 10 people worked on that? Pfft, really? Anyway, the reason why they file for all these patents is their head's on a stick. They're there to scare you away. Very, very few patent lawsuits ever go to trial because it's just too damn expensive. There's also something called treble damages. If you know a patent exists and you knowingly violate it, they can triple the damages against you. That can get real expensive real fast. Anyway, the last topic is a trade secret. And these are things that you don't want anybody to know about. And if you go to reasonable measures to protect it, what the law is it preserves your secrecy. And if somebody steals it or misappropriates it, you can sue. Your rights never expire with the trade secret. For example, I don't know if it was you or in another class, but I told them about this process I came with. And the difference in what was key to make that process yield was actually rinsing a silicon wafer. The typical cycle is 2 minutes. I found out if I rinsed for 30 seconds, it actually made a huge difference in terms of the surface science of the material. So, because you can't reverse engineer it, I kept it as a trade secret. Anyway, the thing about IP trade-offs are biomedical companies try to file up to the last minute because it means their patents last longer. That can blow up in your face. I got really upset once because I had filed a patent 1 year earlier. And then I went to the patent office and I just asked the guy, hey, what's going on with my patent? I said, oh, we're holding it because commercialization isn't going to take place for a couple of years. We might as well file it now. And I said, you guys aren't looking into this, but I got wind of that the Japanese are doing a lot of work in this area. You guys better hurry up and file. And they said, oh, don't worry about it. There's nothing to worry about. And then as it turns out, the Japanese did file. I had them beat by 8 months. They filed 8 months after me, but I lost my patent. And so I wasn't crazy about that. File, if they can reverse engineer it. If they can't, keep it as a trade secret. And the thing about your intellectual property is you have to make sure that it lines up to what it is that you want to do. Now, one of the big trade secret lawsuits that are taking place right now and hasn't been settled yet is Lewandowski of Alphabet left, and he took 14,000 computer files with him, and he went over to Uber. And so now Alphabet is claiming that they owe him $2.6 billion in damages, and Uber's claiming, oh, we didn't really get anything from him, it's obvious, and everything else. And so it'll be interesting to see how this one works out. It's pretty standard in Silicon Valley that people walk away with what they've learned from a previous job. But there's a difference between outright stealing an algorithm and just taking knowledge with you. You're allowed to take knowledge with you, but you can't take anything concrete with you. This is why in old Silicon Valley, if you told somebody that you were leaving the company, they walked you out the door. They didn't bother with the 2 weeks or whatever. They walked you around the door. They would pack up all your stuff and just give it to you because they're that sensitive about competition. The thing I thought was dumb about that is, you really don't think that person would have thought of this first and taken everything? Yeah, it doesn't make that much a difference. Software, the copyright protects creative expression, but the patent covers function and technical merit. There's some controversy about patenting software because if you have a challenge, there's just so many different ways you can write the code. So it stands to reason that two people could come up with the same answer. Be careful about your employees. Your employees can be your leaks of information, and that's where NDA, a culture of secrecy, whatever security you have in place are important for your company. So today in this lecture we've talked about the types of IP, the capital it creates for you, the rules, the legal rules that you have to contend with, the trademarks or marketing tools and copyrights protect your artistic work, and trade secrets have many advantages, including no time limits and no filing cost. However, you have to be careful that your employees don't go out and tell everybody what it is. And that concludes our lecture about intellectual property.